नमस्ते और सत श्री अकाल। मैं हूँ सुषमा अवतानी, a specialist solicitor in divorce and matrimonial finance, and I work at a firm called Taylor Rose TTKW. Taylor Rose TTKW is a top 75 independent firm with over 700 experts operating nationwide. मैं also resolution की भी member हूँ. They are a family lawyers organization who believe in a constructive, non-confrontational approach to family law matters. Right, so I'm going to start today's show by talking about the court's approach to dividing the finances. And this is covered by Section 25 of the Matrimonial Causes Act 1973. The matters to which the court is to have regard to are predominantly for the welfare of the child who has not yet attained the age of 18. तो प्रायोरिटी दी जाती है उन लोगों को जिनके पास बच्चे हैं जो अभी तक 18 के नहीं हुए. With regards to other matters, the court should look at the income, earning capacity, property and other financial resources which each of the parties has or is likely to have in the foreseeable future. They should also look at the financial needs, obligations and responsibilities which each of the parties to the marriage has or is likely to have in the foreseeable future. They should also look at the standard of living. जो आप कैसे रह रहे थे, कितने holidays कर रहे थे, कैसी आपकी standard of living थी before the breakdown of the marriage, the age of the party to the marriage and the duration of the marriage, any physical or mental disability of either of the parties to the marriage, the contributions which each of the parties has made or is likely to make in the foreseeable future to the welfare of the family, the conduct of each of the parties, if that conduct is such that it would be, in the opinion of the court, inequitable to disregard it. जिसका मतलब ये है कि usually behavior या conduct नहीं देखा जाता है unless it's extremely severe. It should be a gasp factor, not a gulp factor. I'll explain what I mean by that later on in the show. In the case of proceedings for divorce or nullity of marriage, the value to each of the parties to the marriage of any benefit which, by reason of the dissolution or annulment of the marriage, that party will lose the chance of acquiring. So ये थे जो factors जो अगर you're going through a divorce and finances का decide हो रहा है court में, these are the factors that the judge should look at under Section 25 of the Matrimonial Causes Act 1973. The overall objective is fairness. क्योंकि कोर्ट को ये देखना है कि वो fair decision ले रहा है. And conduct will almost never enter into the reckoning. The wealth that each side has brought into the marriage will little matter after a long marriage. In one case, the senior court indicated that fairness is about giving each former partner an equal start on the road to independent living. Next is needs. The judge will want to be satisfied that the financial arrangement will enable the separating parties to meet their respective needs. And of course, जैसे मैंने कहा, children's needs are always prioritized. They would want to see that there is appropriate housing for each of the parties of the family, providing secure homes for the children, that there is sufficient money for the outgoings of each of those two households to be met. There is at least some recognition that the parties need to be able to provide for their longer term needs, including in retirement. Needs, of course, is a subjective concept. What is one person's needs could be another person's luxury. The court is likely to take into account the standard of living of the parties during the marriage, अगर वो marriage short marriage नहीं हुई, and the duration of that standard of living. Where the marriage has not lasted a long time, the marital standard of living is unlikely to provide a benchmark for lifelong standards. So agar se shaadi 1 saal hui, 2 saal hui, or it's not considered as a medium to long marriage, then obviously it's unlikely to provide a benchmark for that. It's hard to guess how the courts will address needs where the marriage has not lasted a long period and there are no children. Next, we go on to sharing. Parties to a marriage may be entitled to share equally what was built up during the marriage, and the starting point is 50-50 in sort of medium to long marriages. So, for example, agar एक couple है और उन्होंने 5 million build up किया है during the course of their marriage, then one party might get 2.5 and the other party might get 2.5, so it's split 50-50. There is a concept called wells and wells sharing, and this reflects the idea that where family wealth is built up from different components, then it will usually be appropriate to share the different types of assets between the couple. So what that means is, agar say 2.5 million is in bricks and mortar, and the other 2.5 million is in, say, business and pension, it could be that एक party को business or pension मिले और दूसरे party को घर मिले, which may be worth 2.5 million. So that's the concept of wells and wells. The idea of a quest therefore raises questions over what to do as regards what was brought into the marriage, having been built up before it, and things that fell into the family's lap that were wholly external to the endeavour of the marriage, such as inheritance, and assets built up after the parties separated but before the reckoning up. Finally, there may be different questions for couples who have maintained totally separate financial arrangements during marriage. तो ये भी हो सकता है कि शादी मीडियम टर्म हो, जैसे कि 6 साल की मैरिज हो. मैंने एक केस देखा है जहाँ पे 6 साल की मैरिज थी, and during that marriage it was quite rare, but everything was kept separate. All the finances were kept separate. And उसमें I think the judge made a very fair decision, और जो भी उन्होंने सेपरेट रखा था उनको वही मिला. Sadly जो husband था वो क्लेम कर रहा था ज़्यादा, उसको half of the house चाहिए था, just which he hadn't really contributed to. But because the finances had been kept separate throughout the marriage, just जिनके पास जो भी था वही उनको मिला, which I think was a very, very fair decision. So pre-acquired resources might be respected by way of a downward adjustment to the equal shares that would otherwise be imposed. In short marriages, they could be removed from account altogether. जिसका मतलब ये है pre-acquired resources are assets, or somebody might have, for example, 6 or 5 or 6 rental properties. So मैंने एक दूसरा भी केस किया है जिसमें मेरी क्लाइंट को 5 properties branch properties थे. उसने शादी की, वो यहाँ की born थी, she was British and she married somebody from abroad, वो इंडिया से था. शादी सिर्फ 1 साल चली, और जब finance when an application was made for finances, तो husband ने कहा मुझे आधे properties चाहिए. But because शादी सिर्फ 1 साल चली, it was a very short marriage, उसको कुछ नहीं मिला from her assets, which shows that, you know, pre-acquired resources can be respected by way of a downward adjustment, and as happened in this case जो मैंने किया, उसको sadly or maybe quite rightly कुछ नहीं मिला क्योंकि शादी सिर्फ 1 साल की थी. So it wasn't long enough to warrant, you know, 30, 40, 50%. उसको 50% चाहिए था, but the marriage wasn't long enough to warrant that. In a case dominated by needs, it is quite possible that the pre-acquired resources could be brought into account to the extent that they are required to meet the needs of the parties, including housing needs. So just because मैंने कहा कि इस केस में उसको कुछ नहीं मिला, it does also depend कि आपका solicitor कितना होशियार है, आपका barrister कितना होशियार है, judge का क्या mood है उस दिन, how the judge sees the witnesses, सब उसके ऊपर depend करता है. So it doesn't mean कि इस केस में ऐसे हुआ तो आपके केस में भी ऐसे होगा. It's not set in stone. It does depend on a lot of factors. So अगर कोई ये दिखा सकता है कि मेरी needs हैं, मेरे पास कुछ भी नहीं है, I need to buy a property, I need some money for a deposit to be able to put on a house, then ये भी हो सकता है कि जज कहे ठीक है आपको लंप सम 20,000 मिलते हैं या 30,000 मिलते हैं, या जैसे इस केस में हुआ कुछ भी नहीं मिलता है. So I was acting for the wife जिसके पास इतने सारे प्रॉपर्टीज़ थे, and वो बहुत खुश हुई क्योंकि उसकी शादी सिर्फ 1 साल चली. The extent to which after acquired resources may be retained by the person who has generated them may depend upon the extent to which their roots lie in what was being done during the marriage and whether the separation was complete and the length of the separation before the court is looking at the issues. And things that were wholly external to the marriage partnership, such as inheritances, will not be automatically shared. So, it does depend on many factors. कोई clear-cut answer कोई किसी lawyer के भी पास नहीं है, because it's the judge at the end of the day who takes the decision. एक दूसरा केस भी है जिसमें I would say that it's always better कि आप lawyer use करें अपने डिवोर्स के लिए या फाइनेंसेस के लिए, क्योंकि बहुत सारे लोग हैं जो कहते हैं ठीक है सब कुछ ऑनलाइन है, हमें थोड़े से कॉस्ट्स बचाने हैं और हम खुद कर लेते हैं. And then they do the divorce, they get the decree absolute, but finances are just left open. There's no time limit, so अगर किसी का decree absolute आ भी गया, divorce हो भी गया, there's no time limit within which to make an application for finances. So I will talk about that shortly, but एक केस जो मैं जानती हूँ उसमें the divorce happened the divorce was finalized in 2006, so 14 साल हो गए, and उन्होंने खुद किया. She did it online. Actually, she did it herself without using a lawyer. She didn't do it online. She did it by the paper form, but she didn't use a lawyer. तो अभी क्या हो रहा है? इतने सालों के बाद, 14 years have passed. कभी-कभी उसका husband एक चिट्ठी लिख देता है from a solicitor saying that उसको आधा चाहिए. And now इस लड़की के पास 3 properties हैं और लड़के के पास कुछ भी नहीं है. तो अभी भी इतने सालों के बाद वो चिट्ठी लिख रहा है और कह रहा है, कभी-कभी पता नहीं उसको क्या हो जाता है कि मुझे अभी हाफ चाहिए. फिर वो रिप्लाई करती है अपना लॉयर करके, फिर वो चुप हो जाता है. फिर 3-4 साल के बाद फिर वो लिखता है कि मुझे आधा चाहिए. So you've left those claims open, and just imagine the amount of stress one is going through, knowing that now they've got 3 properties, they might have 5 or 6 properties in a couple of years' time, and they've left themselves open to claims from their former partner because they haven't got a final sealed order or they haven't got a consent order, and they've just left themselves open. So it's always best to seek independent legal advice and get somebody who knows what they're doing to deal with the case, rather than asking friends and trying to do it yourself, because these are the problems that can happen later on. So the courts aspire towards finality, so they would want a clean break. This does not mean that people get less as a result, but it does mean that where possible, the court will make awards to bring the financial claims to an end, apart from child maintenance arrangements, as soon as possible. This might mean, for example, that a financially dependent spouse is awarded a bit more of the pension or a larger share of the assets from which to meet their needs, so that the court can terminate the spousal maintenance claims. इसको कहते हैं clean break, which is ideal. That really is ideal. Okay. So, with regards to these orders that can be made, such as maintenance, adjustment of property, ownership, lump sum, pension share orders, these rights can be brought to an end. The first and most usual way is by way of a court order. Where one or both parties do not wish to proceed with financial claims, and provided the court agrees that such an order would be appropriate, an order can be made dismissing their financial claims, sometimes referred to as a clean break order. The second way is where someone obtains a divorce and then remarries. तो अगर किसी ने डिवोर्स लिया और उसने क्लेम नहीं किया और उन्होंने फिर से शादी कर ली, then unfortunately they fall into the remarriage trap. So unless that person has already applied for an order from their spouse from their first marriage before they remarry, then unfortunately they are caught in a remarriage trap. So जैसे कि मैंने कहा वो लड़की के बारे में जिसके पास 2-3 प्रॉपर्टीज़ हैं, उसने अभी तक शादी नहीं की है और उसके एक्स हस्बैंड ने भी शादी नहीं की है. अगर उसने शादी कर ली, then he will fall into the remarriage trap और फिर वो क्लेम नहीं कर सकता. But क्योंकि उसने भी शादी नहीं की है, वो बार बार उसको तंग कर रहा है और वो चिट्ठियाँ भेज रहा है. But with remarriage आप फिर क्लेम नहीं कर सकते. So the effect of this trap is that they have lost the right to make financial claims against their former spouse. Should the spouses decide not to obtain a court order to deal with financial provision, and in the event that the remarriage trap does not apply, then as I already explained, the claims that each of them have against the other are simply left open. This situation is unsatisfactory in that it creates a degree of uncertainty, and imagine कितना stress हो रहा होगा उसको कि ये कभी भी मेरे साथ हो सकता है, मैंने शायद लॉटरी जीत ली तो मुझे आधा देना पड़ेगा. तो it creates a degree of uncertainty and stress because it leaves the possibility of one spouse making a claim against the other at any time. That said, where one spouse's financial position is likely to improve substantially, it may be in the other's interest to delay a final financial statement. So my advice would be is to seek independent legal advice. Don't leave yourselves open to claims. हमारे फीस सिर्फ £500 हैं straightforward divorce का. Obviously finances and children are always dealt with separately. But for a straightforward divorce, it's महंगा नहीं है. It's better to use a solicitor and get legal advice. Okay, right. So, as I explained, claiming many years after the divorce is possible. So, एक case में somebody made an application after 18 years. So this case is called Wyatt and Vince. A couple divorced, and neither party had any document relating to the divorce proceedings other than the decree absolute. तो क्या हुआ कि 2011 में the former wife lodges an application for a financial order. The husband applies for an order that the wife's application for a financial order be struck out under Rule 4.4 of the Family Procedure Rules 2010. In 2012, the High Court dismissed the husband's cross-application and ordered the husband to pay interim periodical payments to the former wife. In 2013, at the Court of Appeal, they set aside the orders and struck out the wife's financial order application. The wife then appealed against the strikeout. So, ये वाइफ क्यों ये क्लेम कर रही थी इतने साल बाद, after 18 years? क्योंकि वो एक council property में रह रही थी. It was in a poor state of repair. She relied on part-time work. वो benefits भी ले रही थी. So, what had happened during the last 18 years is that the husband had set up a commercial supply of wind power, and his businesses were valued at 57 million. और उसने दूसरी शादी कर ली थी और उसका एक बच्चा भी था. But ये जो औरत थी उसने शादी नहीं की थी. She hadn't remarried, and the court has a duty to consider all the factors under Section 25 of the Matrimonial Causes Act 1973. So, following the Supreme Court decision, it was listed for an FDR, तो hearing हुई इसकी. No settlement was reached at the hearing, but some months later a compromise agreement was reached, and the court were invited by the parties to approve the terms of the settlement. The consent order provided for a clean break, to the effect that the husband would pay the wife a lump sum of £300,000 as full and final payment. His lordship provided that as to the terms of the settlement, he was perfectly satisfied that it was reasonable and that the wife was entitled to receive a modest capital award following the breakdown of the marriage. The court stated that the husband did not see it that way. वो ये नहीं, the husband believed इतने सालों के बाद कि उसका claim, she shouldn't be making a claim, but उसको litigation में नहीं जाना था. उसको पता था कि वो lawyers करेगा, उसमें बहुत सारे fees जाएंगे क्योंकि उसकी application बहुत complex है. अगर उसका business ही 57 million है तो imagine the amount of work that any lawyer would need to do. So he just explicitly offered this sum merely to weigh off this litigation at this stage as cost effectively as he could. And usko 300,000 mile, even after 18 years of making the claim, and by the time jab usko mila ye paisa, it was 22 years had passed since she had divorced her husband. Isliye it's best to either get a consent order drawn up, and sadly some cases are not dealt with amicably, and they go to court, they go to all the hearings up to a final hearing, and then they get a sealed order. But one way or another, this should be sorted out and not left open. So, the Section 25 criteria looks at the actual income of parties and potential income. It takes into account overtime. It considers what the spouses could reasonably be expected to earn. And एक केस मेरे पास ऐसे भी आया था जहाँ पे husband ने voluntary redundancy ले ली थी और उसने कहा मेरे पास पैसे नहीं हैं, मुझे अपने wife से half चाहिए. So the judge would consider the unemployed person's failure to actively seek work. तो just because उन्होंने job छोड़ दिया, उसने voluntary redundancy ली, redundancy नहीं उसको आई, he took it voluntarily. मतलब उसके मन में कुछ था कि अगर मैं दिखाऊंगा कि मेरे पास पैसे नहीं हैं, उसने लोन भी लिया जब कि उसकी ज़रूरत भी नहीं थी क्योंकि उसको redundancy payment मिले, अच्छी redundancy payment मिली, फिर भी उसने लोन लिया ये दिखाने के लिए कि मेरे needs मेरे पास पैसे नहीं हैं. लेकिन जज सब ये देख सकते हैं, they can see that उसने खुद अपना जॉब छोड़ा, खुद ये ऐसे लोन ले रहा है जबको उसको इतने सारे पैसे मिले. और जज ने उससे पूछा भी कि आपने लंप सम जो आपको मिला आपने उस पैसे से क्या किया, और उसने कहा उसने इतने सारे हॉलीडेज़ लिए, तो फिर ये कैसे कह सकता है कि मेरी नीड्स ज़्यादा हैं और मेरे पास पैसे नहीं हैं. So At the end of the day, justice always prevails. In my view, it's always best to be honest and upfront. And upar wala hai, and justice always prevails. That's what I like to say. The wife, I've just been told we've got a few minutes till the end of the show. Wow, that flew by very quickly. But just quickly to add that the wife had worked very hard in this case. In all her life, she had been working very hard. So I think it was a very good outcome that usko kuch nahi dena para. So that was a very good one. And just quickly, financial resources of any new partner may only be taken into account insofar as they release spouse from certain financial obligations. तो अगर आपका कोई new partner है और आपका केस चल रहा है और अगर आपका new partner बहुत सारे पैसे कमा रहा है, so the judge can say that आपका new partner contribute कर सकता है, इसलिए आपको थोड़ा सा कम मिलेगा settlement में. So having a new partner can sometimes make a downward adjustment to your award if that partner has more resources, because then you would have more resources available for your former family. With regards to business assets, the court tries to avoid making orders that will adversely affect the business, as this is the income earning asset. तो जहाँ पे किसी का business चल रहा है, it's very unlikely that a court will make orders that will affect that business or will affect it in a negative way. So just to repeat, it's best कि I know अभी तो divorce तो online हो गया है. It's a quick process, but for reasons I've already mentioned in the show, it's best to obtain legal advice. आप consultation book कर सकते हैं. मेरा number screen पे आ रहा होगा, which is 0207 600 1313. आप consultation के लिए आ सकते हैं to come and discuss your requirements. And like I said, जो actual divorce होता है वो usually straightforward होता है, but when it comes to children and finances, then उसमें थोड़े complications usually आ सकते हैं, and it can take a while for that to be dealt with. Okay, so we've got last 1 minute to go. So just one more thing before I go, just to let you know, contributions made towards the family. A person who looks after the home and children contributes as much towards the welfare of the family as the other who works. So ये मत सोचिए कि मैं घर पे बैठी हूँ, children को look after कर रही हूँ, मेरा husband जाकर अपना business चला रहा है कि आपको कम मिलेगा, because you know, they contribute as much as the person who works. इसके भी थोड़े मेरे पास cases थे, but I'll have to discuss that with you at the next show. So I'll be back with another topic next Tuesday at 7 o'clock, and I'll bring you another interesting topic. But for now, from me and the whole team at MATV, have a lovely evening and good night.